Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and today we are going to be talking about intellectual property law basics. Now, just a small introduction for myself, as I am a legal technology attorney, and I deal a lot in the area of legal technology, but when I was a younger man, I actually worked at the patent redaction department at Applied Material, AMD, I worked for a man who unfortunately just passed away last year, at the later part of last year. His name was Bob Mulcahy, and he was a intellectual property attorney both for AMD, but earlier in his life, he had been the IP attorney for 20th Century Fox, and he did all the Star Wars licensing with 20th Century Fox and with George Lucas, before he had Lucasfilm established. And so he had a lot of really interesting stories about working with George Lucas and getting the licensing for Star Wars all put in place. And one thing that he had told me was that 20th Century Fox didn't really believe Star Wars would be as big a property as they thought it would be. And so there were a lot of things that were unnegotiated with George Lucas and that had to be hammered out after the fact. Once Star Wars was a big hit, then they really had to figure things out. And he said, like with anything that has to deal with intellectual property, the more you can plan for ahead of time and put it into your contract, the better you're going to be, rather than having to figure it out later. Of course, victory has many fathers, but failure is an orphan. So he said, it's not a big deal if your idea doesn't go anywhere, but if it's successful, everyone comes out of the woodwork and wants to claim credit for it. And you have to be prepared for when something like that might happen if you've got a great piece of intellectual property that you're working with. So let's start at the very, very, very basic level, intellectual property. Let's define what it actually is. And intellectual property has been built into the Constitution, saying that the Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So even the founding fathers understood, well, of course, one of the great founding fathers was Benjamin Franklin, who was a well-renowned inventor and wanted to get credit for these inventions that he had. So there was always a balance kept between letting the author or the creator have the value of the invention or the thought or the creation that he or she made, yet to limit that eventually so that things would, over time, become part of the public domain. And so there is always that balance going on, that trademarks, the copyrights, that patents and the other things that we're talking about will eventually expire, allowing things to become part of the public domain. But until they do expire, the rights that the owners and the creators have over that intellectual property is very strong. So it's a kind of a mutual exchange. They give you a lot of power, but that power doesn't last forever. So the two primary purposes of intellectual property law are to encourage creativity and or investment for research and development by rewarding innovation, and to protect investors from improper competitive activity. Okay? There's sort of a third purpose of intellectual property law, and that it's kind of works in a secondary way, which is that by allowing people to know what things are genuine and what things are part of a known process or a known trademark or a known copyright, that they are getting a certain quality of product or a certain quality of or originality of the things that they're investing in, and that they don't get cheap knockoffs or things that look or seem similar but are not actually benefiting the original artist and or the consumer that is intending on purchasing the original article. So that's one reason why we see, even with the fact that this is United States law, that most other countries follow a lot of these tenets because it's something that allows everyone to benefit, but also gives, by making things public domain, but also gives them the quality of assurance that what they are purchasing is genuine and the real article. So there's three types of intellectual property, as I just mentioned before, and that is that there are patents. Okay, so people are familiar with ideas that are patent, or sometimes they see a thing saying patent pending on a device or a item that they're using. Then there's trademarks, and then there's copyrights, and they are often mentioned with each other because they're very closely related, but they aren't the same thing. One protects a different level of the other, and while there are certain trademarks that can be covered under copyrights, they cover a different kind of protection in the way that they actually operate, and we'll be discussing that later. And then you have trade secrets, okay? And today we're not really going to be talking much about trade secrets, and that is because the government can only protect the first two. There are unfair practices that the government can do something about with trade secrets, but it's a trickier part of the conversation, and I really didn't work it into this discussion. So we're really going to be talking about patents and trademarks, copyrights. The main thing about trade secrets are that, they are secrets, so you've got to keep them secret, and the duty is upon the creator of the trade secret to keep that item secret, and it's not the government's responsibility. So usually there's not much I can say about it other than what strategies are to keep your trade secret secret. Maybe we'll talk about it in a future lecture. So do trademarks, copyrights, and patents protect the same thing? No, trademarks, copyrights, and patents protect different types of intellectual property. A trademark protects brand names and logos used on goods and services. A copyright protects an original artistic or literary work, and a patent protects an invention. Okay? And yes, you can have one item that has all three things. The item itself can be a trademark. The item itself can be copywritten, and it can contain processes or particular novel ways of doing things that would be considered inventive. And therefore, one item may have a trademark, copyright, and patent associated with it, or it may just have a copyright and patent associated with it, or it may have a trademark and a copyright, but not a patent associated with it. You can have one, two, or all three associated with any particular item at any point in time, but not everything qualifies for all three. Usually the patented items are separate, are much more separate than the trademarks and copyrights. Whereas a lot of times an item that you'll be trademarking, you'll also eventually be getting a copyright for those items as well. That just tends to be the case, but isn't always. For example, if you invent a new kind of vacuum cleaner, you would apply for a patent to protect the invention itself. But you would apply to register a trademark to protect the brand name of the vacuum cleaner. You might register a copyright for the TV commercial that you use to market the product, okay? Because they're all different things. The TV commercial you would want to copyright based on what the people are saying in the commercial. And when people are saying that there's a certain way of vacuuming and a certain sort of song associated with it, those are all things that create an actual novel concept behind what the commercial is about. And the actual words and what is being said is something that can be copywritten and protected because it was something you came up with to promote your product, your patented product that has a trademark associated with it. So that's how all three things can work together for one product. So let's talk about patents, okay? So you get long-standing protection for patents for 20 years, which I guess sometimes doesn't seem like a long time, when time moves forwards as much as it does. But the idea is that, they want to get things out into the public stream of commerce so that once a novel idea has its patent expire, then that patent, people can use that item to maybe refine it or to build other things based on that item and incorporate that item without having to necessarily license that item indefinitely or have to do it in perpetuity. But there are very powerful penalties for violations. We'll be talking about that later. And if you have seen the news, I'm sure you have seen instances of major patent violations being sued for the hundreds of millions of dollars from different companies. It does give people that incentive to come up with a novel invention. And when I mean novel, it really does have to offer something that wasn't in existence prior to what you had. And when I studied patent law, it's not the most exciting thing in the world, but it is definitely intellectually challenging to describe like the shape of a remote control, an exact shape of a TV remote, and to describe the layout of each and every button, and to explain how the particular button function works in a way that is unique from other remotes that you may have seen. If you're patenting, say, a different remote control, for instance, as an example, and then having to explain how, say, this button works, you have to, in writing and in the English language, describe how the button is set up, how it moves, what degree it moves to. Does it click? Does it light up? Does it make a noise? That sort of thing. Does it? How does it then click onto a particular circuit and complete a circuit so that the signal gets sent through the remote to the infrared sensor or Bluetooth sensor to then make it move, to send a command to a particular device. That's very exacting. And you have to really write up in precise language how that all works. I remember in one of my courses, we were just trying to write up how like a soda can pop lid works, and how a pull tab would work, you know, for a soda can. And that was excruciatingly hard. It was just really hard to describe how it sat on the can, how it moved, what degree, how someone uses it. It has to be written in a, can't be written so scientifically that no one can understand it. Yet, if you leave out something critical as to how that patent functions, you won't get your patent. And so it's pretty difficult. It's controlled by the US Patent Office. And there are several different types of patents that provide protection to invention. Most common type is the utility patent, which I was just talking about. And then there are design patents, plant patents, and method patents. An inventor who wishes to obtain a patent would first have to have his or her attorney conduct a patentability search to determine if a patent is available for the invention and how broad the protection will likely be. Now, you don't have to have an attorney do this, but what happens is if you go to all the trouble to write this up yourself, in fact, there are a number of patents that are filed by people who are not attorneys. And actually, one thing that I just learned about over the July the 4th weekend is that Abraham Lincoln is the only president, US president, to hold a patent. And he actually filed a patent. Well, he was a lawyer. He wasn't a patent attorney, but he filed for a patent for a special bridge barge that would raise up in cases where you had a river, you needed to float a ship over a sandbar. He had a way of lifting ships over a sandbar and transferring them over the sandbar. So if you had rivers that were a little bit too shallow, these ships could pass over it. But he never actually built one. He only built a prototype, and that's all there is. But he's the only president who has a patent. So you don't have to have an attorney do it. The only thing is if you get an attorney to do it, they are specialized in searching the U.S. Patent and Trade Office using a variety of keywords and techniques that will likely find a existing patent if there is one. If you file something without knowing that there's an existing patent, you will get your patent denied. Problem is, the way they deny your patent is not like that they will say all the time, your invention would violate patent X or patent Y or patent Z. They just say your patent would violate, will unfortunately violate a particular patent, and then they won't give you any more information than that. And then you basically have to go and discover it yourself and modify your existing patent enough to not violate that patent, or you'll just keep getting denied. And it's not fun and it's not cheap to have your patent constantly getting denied. So that's something that why people hire attorneys to do this, so that they can get the process done correctly the first time around. So the patent application consists of two primary parts. One is the specification, including a written description of the invention and or any drawings necessary to understand the invention. It must contain enough detail so the person of ordinary skill in the art could reproduce the invention without undue experimentation. And it must disclose the best mode of making the invention known to the inventor at the time the application is filed. Again, something that is not so easy to write up in English. And if you get attorneys that specialize in writing these sort of things, they know what the patent agents are looking for, what the examiners are looking for, and they can word things in a way that make it more likely that your patent will be accepted than denied. The claims area then defines the legal boundaries of patent protection conferred on the inventor by the patent. So claims are the heart of the patent. Once a patent issues, claims will be used to determine if other products fall within the definitions set out by the claims and therefore infringe the patent. So in other words, the claims are what your invention does and why its novelty is something that you came up with and deserve to be protected. Okay, so if you are short on what you claim and you're not specific enough, or you're too general, they will strike down. If you're not specific enough, then they will say that it's too general of a concept, and they'll say you don't deserve protection for that. If you say something is really narrow, they'll say, okay, that's all you get protection for, and you don't get anything outside that. What you said is your invention. And sometimes people will say, well, but I meant to cover this and that as well. And they'll say, well, you didn't put it in there, you don't get the protection. So they really don't want somebody who has one item using it as a way to keep other inventors from inventing things that are close to it, but have a different process or a slightly different function or are helping in a different way. So patents only give the owner's rights within a geographic area, and the protection offered by a patent ends at the national border of the government that granted the patent. But then you must file a patent application in every country where patent protection is required. International treaties, including the Paris Convention and Patent Cooperation Treaty, simplify obtaining patent protection in foreign countries. U.S. patents will prevent foreign entities from making, using, selling, and offering for sale or importing any product or process protected by a U.S. patent, but it doesn't necessarily mean that you're able to use it in another, that you get that protection in another country unless you file there. So a lot of times, if it's going to be a big deal, and you're looking at marketing in different countries, you'll want to look into filing patents with different associations, such as like the European Economic Union and or China and so forth. Make sure that it's covered, that your patent gets protection worldwide if such an item has worldwide appeal. Patents must be in the form of some kind of file. And so you want to look at agents or attorneys that help with the filing. So there are fees that are involved with patents. I mean, it's not free to do so. And I don't know what the absolute current rate is for filing a patent. But when you add in both the fees involved with just the filing itself, which is several $100s, plus what it costs to have an attorney help with the paperwork, a lot of times that investment can be several $1,000s. So you need to also think about whether your device has enough marketability to make up for what it costs to file for the patent in the first place. And again, you've got to look up to see if that patent is similar to what has already been filed. If something is filed and awarded a patent, that is proof that your invention came first. Now, there are ways to dispute this, but by and large, the government is always going to side with the patent holder unless they can show some terrible misdeed that was taken, like somebody had a gun held up to their head and said, you can't file this patent or we'll shoot your dog, kind of hostage situation. They're going to say that because someone filed that patent first and you were on notice because all you needed to do was check your patent request and word your patent request well enough, and you would have found the existing patent of which it violates, and you wouldn't have filed for a patent, or you wouldn't have built an item that incorporated that item's patent without licensing it and getting permission from the patent owner to be able to use that patented item in your particular invention. So that's really important to get yourself registered and to get that same kind of protection yourself, and to make sure that you're clear of using anybody else's patents and that you're not trying to incorporate somebody else's patent in your particular invention without giving them credit. Again, we'll see some examples of how that works later to detriment of some companies. There are very strong penalties for violation. So that's the big exchange, that for people to, get these patents and to go through the process and to spend the money to get a correct patent granted. The other side of it is that the government will do what it can and award extremely strong penalties, including the destruction of items, the disgorgement of funds and monies that are earned, and penalties, civil, including significant monetary fines for violating these patents. The court wants to limit patents to exact copies so that future inventions can happen. The court is definitely wants to make sure that the limits are closely tailored to certain patents, so that one person doesn't claim that they have 100 different patents associated with one item, and that any possible permutations would be covered by this. Because if they do, then people will be they'll be disassociated from wanting to go and try to make inventions, because they'll be afraid that they'll be violating this person's patent, whether or not they could realize it or not. And so the idea of closely tailoring it means that other people can invent things that are similar to this, or that might work off of an idea that this starts with, and then this would lead to another invention that would then help refine the process, or that could make the process work better or faster or longer, or help more people. And so that they would benefit more people based on how it interacts with a previous invention. So they're trying to get a mass number of inventions. The idea is to just make sure that the idea itself isn't being completely copied by someone else. That's what they're trying to protect. And so, for instance, here's an example of how they closely tailor a patent decision. This was Kellogg versus the National Biscuit Company. And a man named Henry Perky made this pillow-shaped cereal he called shredded whole wheat. And Harvey Kellogg said that the cereal was like eating a whisk broom. And critics said it tasted like a shredded doormat. But the product was very successful. And in 1908, Perky died, and his 2 patents on the biscuits and the machinery expired in 1912. So the Kellogg Company decided to sell a similar type of cereal. I think we all know is frosted mini wheats, or frosted wheat, or shredded wheat, and he was sued by the Kellogg's company was sued by the National Biscuit Company. It was the successor of Perky's company. The Kellogg Company argued that the new shredded wheat was a trademark violation, an unfair competition, and Kellogg viewed the suit as an attempt of the National Biscuits Company part to monopolize the shredded wheat market. And in 1938, the case was brought to the Supreme Court, ruled in favor of Kellogg's on the ground that the term shredded wheat was not trademarkable, and its pillow shape was functional, and therefore able to be copied after the patent had expired. So the idea, well, first of all, we'll talk about how shredded wheat is not a trademarkable term because it doesn't have any novelty to it. It is simply descriptive of the product. It doesn't actually say, it wasn't like when we see Kellogg's used as a trademark or the National Biscuit Company, that's a trademark. But shredded wheat itself, without, when they call it shredded wheat, it's just a descriptive term. So that's, it's like steak or hamburger, or, it's what the item is about. Therefore, it wasn't trademarkable. But the fact that the pillow shape was considered functional and therefore able to be copied, because they said there was nothing really novel about the shape itself, the shape of the wheat itself in that pillow form was neither trademarked by the shredded whole wheat company, by National Biscuit, nor was it found to be such a novel concept that no one else could ever think of that shape to use for the wheat. And then the other patents had expired, so they didn't have a right over that shape or the term, and therefore we now see that shredded wheats and all that are available all over, in many different forms, not just from Kellogg. Then in the Samsung situation, where a jury awarded Apple $539 million for patent violations, Samsung was forced to pay after 5 days of deliberations. They said that this feud, which had dragged on for years into its final stage, was based on the $539 million award was given to Apple based on Samsung copying too many different features for its smartphone. Apple filed a lawsuit saying that Samsung smartphones and tablets slavishly copied its product. They were found liable in 2012 trial, but a disagreement over the amount to be paid led to a retrial over damages. And it took almost 5 more years, actually 6 more years, for them to come to this decision for the $539 million award. So yes, the awards can be huge, but the process is not exactly super quick. And so what took, a problem that was raised by Apple in 2011 to get finally adjudicated took them basically 7 years. And not sure, but it could be that Samsung already made the $539 million back over 7 years worth of being able to sell certain smartphones that have those features. It's questionable. So the system does have the ability to enforce itself with really large fines, but it also does have the problem of being, like any court system, kind of slow, and sometimes justice doesn't quite move as fast as you'd like it to. So now let's talk a little bit about trademarks and copyright. Trademarks equal the identity, the association, and the affiliation with a specific brand. Okay? And copyright is the protection from exact duplication or copying of a specific style. And yes, they often get mixed in with each other because trademarks usually are often incorporated in the copyright material of most of the documentation that goes along with items, either for marketing or for instructions or user manual or so forth, or ads or anything along those lines. You'll see the name of a product featured in those things, and then the trademarks become part of the copyright because they are part of what is a novel expression of in writing, usually describing the product or advertising the product. So both can be registered, but neither one has to be registered. This is one thing a lot of people are not really aware of. And that is you do get common law copyright protection even without filing it with the U.S. Copyright and Trademark Office. It's true. You do get that. You have to be able to prove though that you have already used that item in commerce and that the other side would reasonably know this item has been used in commerce before they filed for their trademark and obtained their trademark, or were using something in conjunction with your trademark as well. So in other words, and as I was saying before with patents, registration is proof that others were on notice. Okay. And so when you have something that's registered with the trademark office or the copyright office, they can say, look, if you wanted to use something, or if you weren't sure that it was trademarked or copywritten, you could have checked with the U.S. patent trade. You could have checked with the trademark office, or the copyright office, and found that there was. There are online search engines that you can use to do that sort of thing. And of course, we've seen ourselves the little thing that says trademark, it says copyright on it. And that in itself is a notice to other people that this thing was copywritten prior to your use of it. But again, you have to use proof that it was used in commerce prior to when the claim is needed. And you have to show that the other side would have or should have notice of your existing copyright prior to its use by another party, or else the court is not going to see things in your favor and say, you know, there are people who have similar copyrights over different items that are so locally based that and trademarks over items that are the same name but in different locations, and their market is so different that they're allowed to have the same name and or similar trademarks because there's no confusion over what they do or what their service is. There wouldn't be anyone that could confuse their product with somebody else's. You know, if, for instance, you had a Smith's lawnmower company versus Smith's beer, you know, that the court may say that both can be named Smith's because it's the name, you know, your personal name, if that's the case, but also that your markets are so different that you're not likely to interfere with the other. Someone wouldn't necessarily be buying Smith's beer and thinking that, oh, it's got to be the same company that makes the lawnmower. Okay, that's not an exact case, but that's kind of where I'm going. So one big element of trademarks and copyrights and a defense to the violation of a trademark and or a copyright is the fair use doctrine. And if you can claim that the reason why you're using a specific item is based on fair use, you need to meet these 4 different factors. And that one is, and this is the problem is the only way to get a definitive answer is getting the 4 factors adjudicated in a court. And there really is just a case-by-case basis on how they decide these sort of things. And you'd love to be able to say there's a trend, and that you know for sure that something is fair use or not fair use. But it can be very tricky. And so here's a 4-point test that the courts have used to determine if it is fair use or not. And one is that it's the purpose and character for your use. And we've seen a lot of times that when things are used for parody, and when they're used for satire, they're allowed to use the trademark of something as a way to make fun of it, and that's allowed. The nature of the copyrighted work, the amount of sustainability of the portion taken, and the effect of the use upon the potential market. So all these things sort of have to be weighed out. As I was saying, if someone is saying that, you know, a particular craft, locally brewed craft beer in Missouri would be in conflict with, say, somebody who makes candles locally in Oregon, and Oregon only sells candles to the people in Oregon. They don't have a website. They are just running out of their garage. Meanwhile, the person who's making craft beers wants to get on the web and wants to be able to sell his beer throughout the region, including a couple of states. Probably it's unlikely that the candle maker in Oregon would be able to stop the beer maker in a different geographical area, because there wouldn't be a way to say that how the expansion of this person using a similar mark to you would be confused with what you do as a candle maker in Oregon, that's thousands of miles apart and not really competing with them in the same thing. Now, there was I couldn't find it. It was a number of years ago, but there was a situation where there was Coors Beer sued the maker of Coors, Corrs, apple cider, hard apple cider, because it was not only it was an alcoholic drink, so they were similar alcoholic drinks. The names were similar, but Coors chose to use a script that looked a lot like Coors, with kind of the same, not the exact same script, but looked similar to it. And that was deemed to be a trademark violation because the market was so similar, alcohol, and that the name was so similar. You could, if you looked at it from a distance, you wouldn't really be able to tell if it was Coors or Coors. The R and the O were small enough that it could be confused that way if you just glanced at it. And then finally, the real killer was them using the same kind of script form that Coors was using, make it like a script handwriting. They just said there seemed to be too much of an intent there to try to emulate the Coors logo, and that it would be likely that people in the same market would think that the maker of Coors was the same as Coors. And so if there was a problem in quality with Coors, they would maybe disassociate that with Coors, and Coors didn't want that done, so they did have to change their logo. So trademarks are to make sure that there are no brand confusion. The U.S. Patent Trade Office examines every application for compliance with federal law and rules. The most common reason to refuse registration is the likelihood of confusion between the mark of the applicant and the mark already registered or prior filed pending the application owned by another party. And so the U.S. Patent Trade Office determines that a likelihood of confusion exists when both the marks are similar and goods and or services of the parties are related to such that consumers would mistakenly believe they come from the same source. Similar marks or related goods or services by themselves are not enough to support a finding of likelihood of confusion unless the court has held the mark is actually a famous mark. That is, generally two identical marks can coexist as long as goods and services are not related. Okay, so that's where some people get a little sue happy and sue someone over an existing existing mark that looks similar to theirs, but they don't fully analyze how much the goods and services are related. And if they aren't related, like the Coors example, Coors versus Coors example, even saying it is not as easy to confuse. It's not likely to be. Again, the court wants to try to hold the trademarks are narrow in their interpretation. It doesn't want to just hand out one trademark that covers all possible permutations of that word or that saying. And again, you can't use a descriptive word of something like a beer and trademark that. You know, you can trademark a name, but you can't trademark the actual like item itself. If it's Big Mac hamburger, you can trademark the name Big Mac, but you can't trademark the name hamburger because that's a description of the item itself. A really great example of a trademark suit was the WWF, now known as the WWE, versus the WWF, World Wildlife Fund. World Wildlife Fund's funding relies on its brand being seen as respectable, caring, sensible, and lover and protector of all living things. So the company known as Titan Sports changed its name to the World Wrestling Federation, or WWF. Okay, so you had the World Wildlife Fund and the World Wrestling Federation both sharing the same name, the same abbreviation, WWF. And they did fight for 13 years. And the World Wildlife Fund won because it was there prior to the WWE changing its name to the WWF. It was always known as Titan Sports and actually had been the Worldwide Wrestling Federation, WWWF, for many years until it did change the name of its federation to the WWF. And so the WWF already had that existing trademark and already been using it in commerce prior to that. Now, the WWF Wrestling Association was trying to say, well, the two of them are in such different products that it doesn't really matter. You know, this should be an instance where, because the groups are different, that there shouldn't be confusion. But they did say in 2001 that the Federation broke a 1994 agreement that had promised to restrict its use of the initials in its business activities. The wrestling company threatened to appeal, but eventually backed down to the Panda and spent millions rebranding to World Wrestling Entertainment, the WWE. It now uses the line, "Get the F out," as its marketing slogan. And therefore, the World Wildlife Fund must be pretty happy about getting away from the WWF and any association with the WWF. It was really a lot of hubris by Vince McMahon, because who was the owner of the WWE, because he really felt like he had control of the WWF trademark in the United States, that an international court wouldn't rule against him. But just because the United States had issued a trademark to the World Wrestling Federation, it didn't hold up in an international court because of the World Wildlife Fund's prior holding of that mark. And so they overruled the idea that the WWE Titan Sports had a separate right to have the WWF logo as part of it. In fact, one of the things was it saying, for all those years you existed as Titan Sports and as the Worldwide Wrestling Federation, whereas the World Wildlife Fund has no other alternative name that was ever known by. And so the Titan Sports had technically 3 different names it was working by, and that was not in its favor. World Wildlife Fund, it's the only use is the WWF trademark. That was seen as, well, the WWF, World Wildlife Fund, gets to keep that, and the World Wrestling Federation had to change to the WWE, and it's been that way now for 20 years. The WWE could have saved itself a lot of time and money to ensure that it was fully distinguished from an almost 60-year-old brand in the first place. So that's the lesson to be learned. And then another famous case was Casey Munchkin versus Pac-Man. And the court indicated that video games appeal to an audience that is fairly undiscriminating insofar as they're concerned about more subtle differences in artistic expression. This case is useful that it indicates infringement can occur when the similarity between 2 works relates to the matter which constitutes a substantial portion of the copyright holder's work. And in other words, matter to which is of value to the copyright holder, regardless of the amount of the alleged infringing work that's similar. Once that determination was made, the court had no trouble concluding that Atari had a good chance of success on the merits of a copyright infringement claim. The fact that North American Philips advertised Casey Munchkin as a Pac-Man type game didn't hurt either. So Pac-Man came first, and it involved this semicircle that runs through a maze and picks up dots. And Casey Munchkin, as we can see from above here, is the top one, was this smiley face that bounced around against these particular ghost-like octopus creatures and would pick up these moving dots that would bounce around this maze as well. So it was similar enough. It was seen to have enough elements of the Pac-Man game to violate the copyright violation of Atari, even though the look and feel was considered to be a duplication of what Pac-Man was trying to accomplish. Therefore, they considered it a copyright violation also of Pac-Man itself. But this is where the subjectiveness comes in. You're not really sure that necessarily something is going to be considered a copyright violation just by saying, well, we didn't copy it exactly, we made it sort of like it. And when the court made this decision, they're saying that things that look substantially like it can also be considered a copyright violation as well. Here are common things that you can protect with a let's talk a little bit about copyrights and the things that you can protect with a copyright, such as written works, including blogs and screenplays and books, dramatic works, musical works, plays and choreography, artistic works like paintings and photographs and sculptures, and software such as what we've seen with computer programs. But you can't protect certain things with copyright. You can't protect a name with a copyright. That's part of a trademark, or if it's too generic, it won't be issued at all. Logo. Companies' logos or other symbols can be designed to create, again, a trademark. Copyright may be able to protect a logo as part of an artistic work, as I mentioned earlier. But trademarks, by and large, are the things you're looking for with logos. And then phrase. Company slogan or other phrases can be protected by trademarks. Although phrases that are part of a bigger literary work or documentation would also be covered by the copyright itself. But in most cases, when you're saying, I can't believe I ate the whole thing, or don't leave home without it, those are trademarks because they are associated with a brand name, and people automatically connote brand names with it. And then an idea. An idea in the form of an invention is what you're looking for with a patent, as we discussed earlier. So there are three basic requirements that work must meet to be protected by a copyright. So work has to be original, okay? So it must be independently created and not copied from something else. There's no requirement that the work has to be unique, imaginative, or inventive, but it has to be original. It has to demonstrate a small amount of creativity. We'll see the questions. We'll see a ruling about that coming up in a little bit of what creativity actually is all about. And then fixed, it has to be in a tangible medium of expression. So in other words, if it's able to be perceived, reproduced, or otherwise communicated for a period of time, more than just when it's immediately performed, then the copyright protection attaches automatically the moment the work is fixed. So in other words, when you create something you draw something on a piece of paper, and it's something, a new character that you developed, Squishy the Worm or something. Well, as soon as you've drawn it and it's been put on that piece of paper and you call it Squishy the Worm, that copyright protection, common law copyright protection, actually attaches to it. Now, again, you can't prove that somebody else somewhere on the other side of the United States also came up with Squishy the Worm at the exact same point in time and decides to also make Squishy the Worm comic, and you make Squishy the Worm comic. And then the two of you see each other at the same time. And you go, well, I'm suing you because you're copying me. And he's saying, I'm suing you because you're copying me. Neither one of you filed a copyright. Neither one of you will be likely to collect because they'll say neither one of you filed this copyright in a way to put the other side on notice that if you were going to try to enforce it on someone, they would be copying your invention, or that you're even in the same stream of commerce with everybody else, with each other. That two independent comics could be offered, comic books could be issued at the same time. Neither one of you is trying to publish it on a national basis. So you do get common law copyright protection. People can't just steal it and say, well, you didn't file it, so you have no rights. You can't, but if somebody comes up with it independently, you can't prove that you were the first one to create it, you can't prove that they stole it from you, then you might be out of luck. And that's why it's always encouraged that you file a copyright over something and or a trademark over something that you feel is a truly novel work. Here's another example. It's the Roger versus Coons situation. Now, Rogers was a photographer, and Coons was a visual artist. Coons made the picture known on the right that was found to be a violation of the black and white picture on the left. And the court found that the similarities between the two images was too close, that a typical person would be able to recognize the copy. Coons' defense was rejected under the argument he could have used a more generic source to make the same statement without copying Rogers' work. Coons was forced to pay a monetary settlement to Rogers. And again, up to you to decide whether or not there was enough difference between the couple, the way the couple was holding the dogs, the way that there were sort of the expressions that they have on their face, the similarity in clothing. Yes, they are different, and they have different colors on, and one's a black and white photo, one's color sculpture, but they're both sitting on a bench, a wooden bench. These things were all seen as being too closely related to be allowed to exist under copyright. Now, on the same level, this particular instance, we saw two different decisions. One is for Carew versus Prince. The judge ruled in favor for Carew, who made the original photograph, over Prince, who made the picture on the right, saying that the photographs weren't significant enough of a change to constitute fair use. So he was found to have violated the copyrights of the photographer in modifying that picture, quote unquote, not enough to make that an original piece of art. However, in 2013, 2 years later, a judge overturned that ruling, ruled in favor of Prince, saying that Prince's work transformed the work in a way that was aesthetically different and therefore acceptable under fair use. So I leave it up to you, the observer. Do you feel that what is done on the right to this picture is enough of a difference from the picture on the left for Prince to have created a separate work under fair use and a derivative work under fair use, as opposed to the judge that originally said no, just putting three purple dots and a copy and paste of a guitar on his hands is not enough to change this picture and to give it independent, copyrightable protection. It's a good thing to ponder. And one judge thought he was doing the right thing in 2011, and then 2 years later, the judge thought it was wrong. So, and then one of the biggest cases of all is Apple against Microsoft. And it was a question of who invented the graphic user interface. And Apple tried to stop Windows from becoming a major operating system. But Jean-Louis Gasset, who had taken over from Steve Jobs at the time, did not want to allow Microsoft to use the software. But he did add features of those early prototypes to the Macintosh. However, there was an agreement put forth between Gasset and Bill Gates, so that at least the Windows 1 version would be using the Mac's visual displays. And when he upgraded it to Windows 2, Gasset said that this was a breach of contract and that the graphic user interface was only licensed to be used with Windows 1.0 and not future versions. So they filed a lawsuit against Microsoft in 1988 and had 189 contested visual displays that said violated its copyright in a 6-year battle. But the court ruled that 179 of the 189 displays were covered under the existing license, and that the other 10 were not violations of Apple's copyright due to the merger doctrine, where the idea expression divide limits the scope of copyright protection by differentiating an idea from the manifestation of that idea. So Apple lost the case to Microsoft, mainly because they had said, for the purposes, it also was discovered that Jean-Louis Gasset had gotten a lot of his ideas from the Xerox Star that was invented in 1977. And so he had originally agreed with Xerox that he would build his ideas off of their ideas, with the idea that he wouldn't try to enforce any future patent cases against any other innovators that were trying to use the graphic user interface. And Gasset had agreed to that and then changed his mind and obviously initiated this lawsuit. And that was another reason why he lost, is that he wasn't even found to be the true original inventor of the graphic user interface idea, and that he had agreed not to enforce it against anyone, which then he did. So the world would be very different today if Apple had won that lawsuit. There probably would be no Microsoft at this stage. Some people feel about that is different, but that's the way it was in court. And it was finally adjudicated in 1993. But we can see that it takes such a long time for things to go through that Windows has already moved up to nearly Windows 95 from Windows 2.0 when they originally filed this lawsuit. So some conclusions here. And that is, intellectual property is protected by three main bodies of law. And that is patent, copyright, and trademark. Each body of law protects different elements of intellectual property. So you can have one, two, or all three in a single product. You have to actively protect your intellectual property or you will lose it, okay? That is one thing that is for sure. We've seen over the years trademarks become watered down, like for instance, a Kleenex. Well, the real thing is that's a facial tissue, but nobody calls it a facial tissue. They call it a Kleenex or a Band-Aid or an aspirin or a Xerox. Certain things have lost their trademark ability due to being used so much and so commonly in the public stream that there's not much you can do about it. So, but while you have the chance to enforce it, especially early in its existence, you need to, or a trademark could be considered and copyrights can be considered abandoned. Filing gives the other side notice that you were the first to license it. Okay, so by filing either copyrights, trademarks, and or patents, you get that first in line connotation by the government, and that really helps in any kind of litigation. Yes, you do get common law, trademark, and copyright protection, like I mentioned, as soon as you write something down, as soon as it's put in a fixed medium, but that doesn't always make a court case easy. What makes a court case easier is when you can prove you have gone to the level of filing and licensing these particular items, and that the other side would have or should have known that such a thing was filed if they had done a search. There will be certain level of subjectivity to any ruling, especially when you talk about fair use. There's no particular way that you can know for sure what a judge is going to say. We just saw in the Prince case that something was decided one way, and then 2 years later, it was deemed to be opposite. You've got to look at other cases that exist that are maybe closer to yours and see, if you have a claim, what the claim was hinged upon, and again, your best way to get protection is by making sure that you have your trademark or copyright filed, and you can say, look, you're on notice, you're constructively on notice that I had something already on file that looked like this, that said this, and that sort of thing. And then of course, the more creativity you can put into an invention or a product or a trademark or a copyright, the more likely it is that you'll be offered protection. So that's my talk for today. If you have any questions, feel free to contact me. I'd be happy to answer your questions. And thank you so much for listening. Have a great day.